Hello, everybody, or anybody that's out there. And apologies for last week. If anybody did turn up and try to watch it, I was having technical problems, and in the end, I gave up. But I'm still having a few technical problems tonight, as you may find. But we're actually all here. The problem last week was that Zoom wouldn't let everybody in or anybody in. But now we are here. So hello, and we've got, unfortunately, Shannon isn't with us, but hang on, I'm just going to get the comments up. And but I'm very lucky to have Mike and Karis here again. And is there anything you guys would like to say before we start off, or before I start talking away?
No, just that nearly legal link. That would be good to talk about if we get a chance.
Yeah. Well, the only bits of news I've got are that I did actually read. I mean, this won't be much interest to anyone who isn't a housing solicitor, legal aid housing solicitor, but the government have put out a consultation document actually yesterday. I won't put it up on screen, but it does confirm that they are giving us a 10% increase in rates of pay for legal aid housing work, which goes some way, because when David Cameron got in 2010, they gave us a 10% cut, and that was after not having increased our rates of pay since 1996. So now we're getting a bit better. I mean, I don't want to sound like, I mean, the problem with lawyers is or people talking about pay rises is it's never enough, is it? But this is a nice start anyway, and it's appreciated. So forgive me if I'm sitting in the top of a house and there's a storm going on outside with heavy rain. But maybe what we should do is move on to the point that Mike raised. But before, about there's a court case which I think I've started trying to read it, but I didn't understand it either. So let me see if I can get to it. I think it is this one here. Let me see if I get the right screen. No. Maybe this one here. Ah, there it is, I think. Yes. So if I mean, forgive me, it's a terrible. The reason that I'm late starting is I was trying to get this set up, but this is from the Nearly Legal blog. I don't know why the top bit is so big and the text is so small, but I'm learning, and I'll next time hopefully we'll get seamless big readable websites. But this is a case called Ivory versus Welling Hatfield Borough Council, and it concerns an issue which troubles many people, which is when you can make a new homeless application, isn't it? And how far did you get in reading it, Mike?
So I didn't read the judgment, but I read the Nearly Legal blog of it. So and there was some bits. So there's always been this bit which I'd never fully understood, and it didn't really help me out, to be honest. I think there were some bits in there which were pretty disgusting from Welling. Like basically, the housing officer was essentially saying, "Well, I've got no evidence of you having like a mental breakdown 8 years ago, so it didn't happen." I'm going to firmly say it didn't happen. And obviously, there's this psychiatrist was brought in and basically said, did an assessment for whatever it was, 90 minutes. But it's just like, I mean, I don't know if you can find a bit. I'm trying to see if I can find a bit at this end. Just the language of the letter, it's just so horrible. And it's not, it's not the worst decision I've ever seen. But I'll see if I can find like what paragraph it's in, because it's just good to kind of sort of realize how horrible housing officers can be.
I must say,
so
I don't know if you had much dealing with Welling Hatfield Borough Council.
Never dealt with them before. No, I've had a couple of run-ins with
from them tonight, actually.
Okay.
My first case, they've found somebody not to be in priority need, despite what seems to be a wealth of evidence to the contrary, and they've given him, they've said his temporary accommodation is going to be cancelled on the 3rd of February, which doesn't give a lot of time. But hopefully we'll have time to get a new judicial review against Welling Hatfield Borough Council up and running. But sorry, Mike, I interrupted you.
No, no. So, but I mean, just to try and, I guess, give an overview of this case. So this is like the same issue I came up against, oh man, 5 years ago, something like that. So basically, the situation was, someone was referred to me who had some significant mental health issues and some pretty significant drug and alcohol issues at the time, and all of that had been admitted for. There's no mention of that within the decision making process. So I then got involved like 8 months later, and the question was, could I make a fresh application 8 months later? Because although the information wasn't considered in the decision, it was available to them had they asked. And so, yeah, it wasn't raised by the applicant. She was in a real kind of mess. And so, yeah, kind of this question of, and it kind of comes up in this case here. So, like, because new evidence came up halfway through the case, which was technically available to the council, but they didn't refer to it or whatever. And in effect, that is, I think that's part of the reason why she was able to make a fresh application. There was also the fact that the housing officer said, well, you should have raised this medical evidence at the Section 204 appeal stage. And then I think the solicitor said, well, we couldn't because it hadn't been raised at that point in the previous setup, so we weren't allowed to raise it at that point. I think that's what the argument was. But if I just read this, so if you go, it's like kind of a quarter of the way down. It says Welling's officer then rejected Miss I's application, stating, "There's nothing of substance provided in the report other than an opinion expressed by someone who, after speaking to you, believes your version of events. This is an opinion given 8 years after the fact. They did not meet you at the time. Blah, 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 blah. There was no evidence at all supporting the statement that you had a mental breakdown and this was your cause of your eviction. I found that the reason that there is no evidence is that it did not happen." I was like, that's such a horrible person who has to write that, like, because this housing officer doesn't know. They haven't got, presumably haven't got any evidence which kind of blows that out of the water, but they're willing to just basically deny someone has had a mental breakdown. So it's kind of like, yeah, I can only imagine what sort of housing officer this is, but it's not. Yeah, as I say, the legal point's a little bit more. I still couldn't quite figure out what the answer was in terms of whether you could trick, because I guess it's relevant if you get like an intentional homelessness decision from someone, it doesn't get challenged within the 21-day limit, and then you come across the case months later, how you can go about triggering a fresh application. Like, is it enough to say, well, actually we've got a medical letter now that relates back to when they lost the accommodation? Is that essentially allowed? So I don't know what the answer is. It seems that the answer might be yes, but I don't know for sure.
I think the key term that needs to be looked at is this idea that it has to be new facts. But
Yeah,
that that's although that seems quite a sort of simple pair of words, this case has demonstrated how lawyers can go running off all day and argue about it. Because whether it has to be new facts that make it a new application, because remember breaking the chain of intentional homelessness, which is sort of related, that if they found you intentionally homeless, you're sort of stuck, arguably, that you're going to be intentionally homeless wherever you go until you break the chain by getting settled accommodation somewhere else, so that your previous place which you lost is no longer the reason you're homeless. And there's a tendency that's quite a nasty test, that one, because it is quite difficult to break. And I think that local authorities like to try to make out that the new facts have to be really sort of relate to the old decision and show that it was wrong. But really, I think that all you've got to do is show that it isn't the same application. So I think that, for instance, it's quite common for people to get told by councils, you've refused an offer of accommodation, we're going to cancel your temporary accommodation, and we're going to, but basically that's it, no further accommodation. Now, I think it's open to anybody to go back to the council and say, hello, it's me again. I'm making a new homelessness application because you've cancelled my temporary accommodation. The council are likely to respond to that by saying, no, 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 we just told you we discharged our duties. And I think you can say, well, no, yeah, that's true, you have, but those were the duties you accepted following my previous application where I became homeless from my old address. Now I'm homeless from this address. Um, and the significance of that is you may be out of time for challenging the previous decision, but the council still have to really, I think, make a decision as to whether you're intentionally homeless or not. And there's a couple of important reasons for that. One is because those are new facts because you've become homeless from a different address. But also, if you're in priority need, which presumably you were in order to get the offer which you refused, I hope you're still with me.
Yeah, no, I'm with you.
Um,
Yeah,
you would then have a duty under Section 190. Sorry, the council would have a duty to assist you, including providing temporary accommodation under Section 190, which only arises, forgive me if I'm wrong, if they found you intentionally homeless. So the decision to say we're treating our duties as discharged and we're cancelling your temporary leaves you with a problem, because if you can't challenge that decision and ask for temporary accommodation pending the challenge, you're stuck. And you can't say, oh, can you give me Section 190 because I'm intentionally homeless? They say, well, we haven't found you intentionally homeless. What are you talking about? So then you say, well, I'm making a fresh application. And that the advantage of that is not only do you get the Section 190, but you also get a second shot at challenging the previous decision, because you can only be intentionally homeless if you deliberately did something, i.e., refused the offer. And if the offer wasn't reasonable, then you can't have been intentionally homeless. Um, that's the way I read it. Sorry if
yeah.
that's made things more confusing than
No, no.
not.
Well, I followed that. So essentially, you're talking about accommodation which has been provided following the main duty been accepted, and then you refuse something down the line. So I think you're absolutely right. I've got compensation for people before on that point. I guess in the case that this blog's talking about is, I think essentially what's happened is this lady has, basically lost her tenancy somehow. Um, Not kind of raised the fact that maybe she was having a mental health crisis at the time, and maybe lack capacity, which would kind of tie in with 9.17 the code of guidance as a kind of a reason not to be intentionally homeless. But then it's been raised, and so yeah, as I say, I think it basically, I think you're right. It basically opens up the door just to have a fresh go at that argument. But there's just a bit, there's some wording in it. It's like, so, in my view, Mr. Trerick, who is the review officer, I think, was not entitled to proceed as he did. He had to consider where there was a new fact by reference to what was said in the doctor's report. Had he obtained answers to questions he asked in his email? Blah 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 blah. Um, yeah, so yeah, I mean, I'm not going to read the whole lot out. Just try to get the salient bit. But in the event, there can be no question of Mr. Trerick having erroneously taken account of any answer in his queries, since none were given. So yeah, you're right. So in one sense, some essentially inquiries were made, but then there was kind of like no actual any sort of decision around it. Yeah, I'm not, as I say, I can't actually find the bits which are going to sort of make the point, but it seemed to be a good decision. Yeah, it seems to be a positive decision for homeless people, as in it leaves open the possibility of making a fresh application. And this probably isn't that unusual a situation, because yeah, often people who are going through a mental health crisis are not going to probably adequately raise various issues that need raising in that kind of review process.
Well, I'm going to go. I got halfway through because the judgment itself is really long. So it's 30 pages, which is
Right.
quite long for a judgment. And I got halfway through it, and it is a fantastic review of the law on making a new application. I mean, that's the beauty of these judgments. It's almost like a sort of chapter in a textbook. It is worded a little bit more sort of fancifully than a textbook would be, but it's got a summary of each statutory provision, the code of guidance, the history of the case law, and some good analysis. But another lesson from this case that I thought for any caseworkers out there, or anybody uh, dealing with a caseworker, is never underestimate the importance of a psychiatrist's report.
Yeah.
Because I mean, I was in court today with a case where somebody had got a possession order made against them 3 years ago. And arguably, I mean, you're supposed to apply to set it aside very quickly. So he was in a bit of a situation regarding how he'd taken 3 years to do it. But the difference would be if I got a psychiatrist to say that he lacks capacity, excuse me, I got a hiccup there. If it lacks capacity to be a party to legal proceedings during that 3 years, everything is blown out. Everything that's happened so far in the case is void, and so he can start all over again. And the psychiatrist saying, "Yeah, this guy couldn't have handled things," and no, and the court should have been aware of that, and the council should. But in this case, I mean, if they got the, and no disrespect to anybody involved in the case, but you can see that the psychiatrist report would have made all the difference in the first place. But you can't, I mean, well, you can, I suppose. The legal aid agency will pay for psychiatrists. Um, they cost about, I mean, to get a psychiatrist report costs about £1,800. Um, and then, you've got to justify that. But the legal aid agency doesn't make much of a fuss. So I would say, if in doubt, get a psychiatrist involved as soon as possible. Um, and also bear in mind that it can take about 3 to 4 months for many. If anyone knows any good psychiatrists out there that can turn reports around at legal aid rates quicker than 3 months, that would be great. Because I find it takes, the good ones take about four. I got an appointment for somebody last week, or a couple of weeks ago, and the appointment wasn't till April, believe it or not. And I asked them if they could bring it forward because it's to try to get somebody out of unsuitable accommodation. They said, "Well, how about March?" And we got a gap, but it's better than nothing. So,
I found the bit I was looking for, Will. If I
oh
just
right,
read it
right,
very quickly. So,
yes, please.
so right at the end, actually, as it
I'll
logically
scroll
would be,
down
yeah, the
for what
overall
it's
position
worth.
is summarised by what's LJ stand for? Lord
Lord
Justice.
Justice, yeah,
Lord Justice Phillips as further application. So a further application must be accepted if it is based on a factual assertion which has not previously been made and which is not trivial or fanciful, or it adduces significant fresh evidence in support of a previously made factual assertion, whether or not rejected. That appears to be an appropriately straightforward test for a housing authority to apply. I don't find that straightforward, but I think so. Essentially, so you could essentially challenge a historic decision, particularly around intentional homelessness, if either a new factual assertion which hasn't been made before is brought to life, or there's some sort of evidence which basically yeah kind of changes a previously made factual assertion. So yeah, anyway, yeah, I thought it was interesting. I'm going to read that. I'll read the full judgment as you suggest, Will, because it's something I've
yeah,
come
me
up
too.
against a few times, and I've never actually had like a firm answer. So maybe the answer's in there somewhere.
Because my understanding is that the local authorities would generally have you believe that the new fact has to be some new fact which shows that the previous decision was wrong. But it doesn't. It just has to be a new fact which hasn't been considered before, which is I was in bed and breakfast or whatever while you considered my previous application. Now I'm not, and now I'm homeless again. And I think that would be enough. Um, whereas the problem you've got is if they find you intentionally homeless and then you go straight back and say, "Hello, I'm back," um, you are stuck then because it's difficult that you're going to get a lot of material facts that are different. Or you may
So,
think I just defeated my own argument there, but
so in the code of guidance, it basically says if where new information arises and it kind of brings to light a change in relevant facts. And so I always took that to mean. So there's a case I do in the training, which is this is kind of comes up in. So essentially there's a guy who's found in priority need through vulnerability, but he's intentionally homeless. He then rough sleeps for a few months, gets attacked, so he's now even more vulnerable. But nothing's changed about there's no break in the chain of causation. And so in one sense, there's a change in facts, he's more vulnerable, but there's nothing that is not there's not a change in relevant facts because it doesn't have any sort of bearing whatsoever on the intentional decision. And so I interpret that to be essentially he was unable to make a fresh application to that council until he had something resembling a combination that might kind of potentially be more than trivial. So
that
that was
yeah,
how I understood it.
I think you're probably right because if you're if they find that you're not in priority need, you could go back and say, "I've got medical evidence. Now my medical situation is different." But if you're intentionally homeless, by definition, they've said, "Well, we're not disputing that you're in priority need. We've never said you weren't." What you could do is if you got medical evidence that was, well, it wouldn't be, would it? In your situation, it's new medical evidence based on events since the last decision. But if you got medical evidence to say, I was mentally unwell before when I made the original decision, then you could invite them to reconsider it. And although they'll
Yep.
probably say, "Oh no, you're out of time. You've only got 21 days." It's not true. You can ask anybody to reconsider anything in the light of new information, and if they don't accept it, you can judicially review them, which is a
There's
lot quicker than a 202 review.
So yeah, I think that sounds right to me. I mean, I really wish I kept, because but it's the initial case I referred to, like, so it would have been 2019, where I had this kind of, and I remember having an email chain with the housing officer, who was one of the worst I've ever dealt with. There's like 25 emails me going back to saying, yeah, but can you take a fresh application? But yeah, but can you take and so, and they just kept, eventually they took a fresh application, but it was ridiculous how they just kind of kept like pivoting to other things. And I was like, yeah, but what about this bit here? And it did work in the end. But yeah, it's kind of most ridiculous email chain I've ever seen, I think.
Yeah, I mean, it's up there with those chains you get where somebody's saying, we're not going to give temporary accommodation because we haven't got reason to believe that they're. And we said, but we hang on, we've told you the person has this medical condition, so you have got reason to believe. You're just not necessarily satisfied. Oh well, we want to make a decision as to whether, and so it goes on. But anyway, I wanted to try and share something with everybody which is not directly relevant to housing law, although it is up to a point in that it concerns. There's many lessons to be learned. It's a bit like the post office inquiry or the post office scandal. There are many lessons for housing lawyers about bureaucracy and what you can expect from the judiciary. But this goes way back to the 1970s and the Birmingham Six. Because if I can take you to this slide, see if this works. I've just finished reading this book by Chris Mullin. Oh, sorry, it's got to go back to the beginning. Sorry. See, I've been also learning how to use. Dear, I've messed it up. But I wanted to share this quote from Lord Denning because I've known about this for years, but I just couldn't. I hear it mentioned. It has. I think it's the worst ever quote from any judge in this country that I've ever heard. And if I can, oh dear, it keeps jumping off the screen now. I will just talk you through it, right? And I'll read it. I'll put the quote there. I had produced a little slide that would take us through it, but I don't think it's going to work. So this is the book Error of Judgment by Chris Mullin, which I've just finished reading. And for those of you that don't know about the Birmingham Six, I'll quickly talk about it because it's in November 1974. There was 2 bombs let off in central Birmingham, and a lot of people got killed. And I can remember. I'm old enough to remember this happening, and it created a sort of hysteria in Britain, which was of anti-Irish sort of prejudice, and 6 innocent Irishmen were arrested that night and actually in Heysham, and I think 4 of them were arrested in Heysham on the way to Ireland, and 2 more in Birmingham. And then later it happened with the Guildford Four, and but quite a few other cases as well. And it was following the in this case there was an organisation called the West Midlands Serious Crime Squad, which was a bit like the Sweeney, except that they were supposed to deal with serious crime, but they spent a lot of the time committing serious crime. And in this case, what they did, which was then standard police procedure, was to when you were trying to solve a crime, what you do is you go out and pick someone, and you either persuade them. Ideally, you pick a sort of mentally vulnerable person. You persuade them to confess to the crime, or if they don't agree to do that, you beat the hell out of them until they don't know whether they did it or not, and they'll just tell you anything they want. So these guys got beaten senseless in prison by the West Midlands Crime Squad. They got them to sign false confessions, which the police had cooked up, and the rest is history. They then got sent to prison for life, and it took until 1991 before they were freed after 2 different appeals. And during those appeals, the Court of Appeal demonstrated how terrible it was at actually scrutinising evidence and looking at things in a fair way. And the second appeal, the judge said, the more I look at this case, the more convinced I am that the convictions are sound. And eventually, thanks to Chris Mullin and Granada TV and people publicising it, they got freed. But one of the things that happened to the Birmingham Six is after they got taken to they got arrested in Heysham. They got taken from Lancashire Police, Morecambe Police Station, where they'd been originally interrogated, and they were taken to Winston Green Prison in Birmingham. And when they got there, I mean, it's mine. You've got to read the book, really. It's anybody I recommend should read this book, because when they got to prison, they were handed over to the prison guards, who also beat them absolutely, you know, terribly. I mean, they were losing teeth, and they were unrecognizable when their families came to see them. So when they lost their criminal case, they then brought a civil action against the prison authorities, and that was a case called hang on a sec, see if I can dig it out. The actual case was called oh, it's actually, the slide doesn't look too bad now. The case was called McElkinney versus Chief Constable of West Midlands. So it was against the police, and it was a civil action to say that they'd been beaten up. And if it could be proved that they'd been beaten up, then they could get the appeal against the conviction, because then they could show the confessions were forced. So it comes to the police applied for this case to be dismissed without a hearing, because they said it's already been dealt with by the criminal courts, etc. And it would be unfair if we have to go through a civil action. And they would have been in a lot of trouble if they had gone through the civil action. But Lord Denning, who, I don't know, people, I mean, do you guys, are you familiar with Lord Denning? Because he's somebody that is, trying to think of a similar person, a bit like sort of Gary Glitter, or well, not directly, but people that were very, very famous and very popular in the 70s, and they've since been cancelled, as it were. And Lord Denning, when I first started studying law, Lord Denning was a sort of held up as the greatest judge of all time, and his judgments were read out. And actually, he's a bloody nuisance, because every area of law that I studied was fairly understandable until this guy got involved and decided to mess it all up. He was famous for doing a public inquiry into the Profumo scandal in 1963, when the minister was sharing a girlfriend with the Russian Russian military consulate, I think. So a very big establishment figure anyway. But I'll move on to the quote. So Lord Denning does dismiss the appeal, but he does it on the basis, not that he doesn't think that they've got a good case, but he thinks that if they did have a good case, the implications of finding that the police had been lying and been violent were so bad that it was better that these innocent people stayed in prison than the society had to confront this. So if I just read this, it's not very long. This is known as his appalling vista speech. He says, "Just consider the course of events in this. If this action were to proceed to trial, it will not be tried for 18 months or 2 years. It will take weeks and weeks. The evidence about violence and threats will be given all over again, but this time 6 or 7 years after the event instead of 1 year. If the 6 men fail, it will mean that much time and money and worry will have been expended by many people for no good purpose." And then, sorry, the next bit is here. If the 6 men win, and I've done that bit, sorry, it's the bit if they, have I done that bit? No, I haven't. If the 6 men win, it will mean that the police were guilty of perjury, they were guilty of violence and threats, that the confessions were involuntary and were improperly admitted in evidence, and that the convictions were erroneous. That would mean that the Home Secretary would have to either recommend that they be pardoned, or he would have to remit the case to the Court of Appeal under Section 17 of the Criminal Appeal Act 1968. This is such an appalling vista, i.e. that these guys should get out because they were beaten senseless and forced by lying police officers to give confessions. That's much worse. That every sensible person in the land would say it cannot be right that these actions should go any further. They should be struck out either on the ground that the 6 men are stopped from challenging the decision of the criminal court, that was Bridge J, or alternatively that this is an abuse of process. Whichever it is, the action should be stopped. Now, the reason I go into some detail on that is because one of the things the Birmingham 6 case illustrates is the superficial nature of British justice, in that it looks impressive, but the judges are so biased in favour of the establishment that you get this sort of thing. And he's let the mask slip here, because usually they say, "Oh no, it's a very weak case," and we if it was true, we obviously it'd be shocking. But he's saying, "No, I don't even want to find. I don't want these guys let out because the police, the reputation of the police would be um, besmirched, as it were." So that's relevant to homelessness appeals, because when you're dealing with, I mean, forgive me, any judges or people listening out there, but I think that the attitude you get from many judges is similar to this, in the sense that they would rather um, think that a housing officer didn't make a mistake than that somebody should have their appeal allowed. And they say, "Oh well, if the council say they made a decision, they thought about all these things." Because they put a section 202 review together which says we carefully considered this, this, this. When they didn't really, they just got now medical to rubber stamp it. But you're sort of banging your head against a brick wall, and part of you, when if you're in there, wants to say, "Oh come on, open your eyes to reality. You know that this is what happens," but they don't, because it would mean that they'd have to admit that the whole system of these reviews, where somebody apparently looks at it afresh with an open mind, is nonsense. And not, I mean, there are good judges and things have got better, but Denning was only one of 3 judges who really made fools of themselves. And I think I might do another video about this in the Birmingham 6 case. So I thought I'd mention that. I hope it's interesting. But if you ever want to see a case where British justice was exposed for basically a sham, and by Lord Denning by accident, then this is the one. And the case itself is called, for those of you who want to read it up, it's called Muckle-Kinney versus Chief Constable of West Midlands, 1980. So I think I said that earlier. And if you want to know more about this, there's a blog post which I was able to copy that text from, which I put the link to there, saying, "Beware of judges employing rhetoric," a note on Lord Denning. And you'll see it again. You see, I mean, I've been looking at the Lucy Letby case, which I have, a lot of people have a lot of concerns about, where you've got judges saying, "Oh, they're so certain that that this is what's happened," and then I suppose I'm biased because all my life I've seen these cases. It was Irish people in the 70s, then it was black people in the 80s, like Winston Silcott, and the people who was convicted of the murder of PC Blakelock. And the thing that is really terrifying, and this will do the parting thought on this one, is that if they hadn't abolished capital punishment in 1965, these people would have hanged. And these attitudes that are shown now would have, there would have been no way that they could have got away with it, because the media was so hostile to them. And for years afterwards, the Sun and stuff were calling for bring back the death penalty for killing police officers. I mean, they still do, don't they? Bring back the death penalty for killing police officers, or that guy in the Southport case. And there's probably a lot of people calling for the death penalty there. I'm not saying he's innocent, but these cases should show that the system is not sufficient to make decisions like that. So it sounds a bit bad for a lawyer to say that, but I think it's healthy to maintain the cynicism about the system.
Yeah, so I had a conversation with the housing lawyer not too long ago where we were arguing the kind of the threshold on vulnerability. And he was saying, it has to be essentially he was saying it's like a really high threshold. You see when it says you have to be significantly, risk of significant more harm. He was saying that's a really high thing. And I was like, well, no, because the Paniotu case, the Smith v Harringer case, says it's just noticeable. And you see, yeah, but if you lower that threshold, then you're going to open the floodgates to lots of people being in priority need. I was like, well, so be it. That there's even a bit in HOTAC which the Supreme Court judges say local authority resource should have no impact whatsoever on vulnerability decisions. It should just be an objective test. So yeah, I think it's and that was a in one sense that was a housing law who's generally on the housing on homeless people's side, but it's just kind of he was like, well, you can't just house all these people. You can't accept this duty to house all these people. So which I
No,
didn't quite understand, but yeah,
another sort of example of the, well, not really the corruption of the system, but the futility of the system is, if you remember, a couple of years ago, there were a lot of cases about, I think the main one was, I think, El Kundi, and where they were talking about local authorities have to provide people with suitable accommodation. It's not enough to say, sorry, we haven't got any. We'd love to, but we haven't got any, because there's a mandatory duty, and it went all the way, I think, to the Supreme Court or
the
and
Court of
they said
Appeal maybe.
yes. But the problem was, I was talking to Sarah Steinhardt the other day at the Doughty Street seminar that I went to, and I said, have you actually come across any cases where judges are actually making orders, either fining local authorities or even worse, in theory, committing housing officers, directors of housing, to prison for contempt of court for not giving them suitable accommodation? Because by implication, if the court says you must provide suitable accommodation forthwith, we dismiss your argument about not having any, and they don't do it, then, and of course she said, no, I haven't heard of any. But I mean, and I think that's why the judgment was so pussyfooting around about, they couldn't actually come out and say, yes, they have to do it. And if they don't, they're in contempt of court. But shall I just get some comments up? Sorry.
There's a question from Anthony.
Uh-huh. Yeah, I'll put them up. Sorry. I'll go back to the screen that's got the, I think this one. So if I scroll back to the beginning here where we've got the first. So hello to everybody that said hello. By the way, I'm going to plug this. This channel is now, as at last checking, has got 99 followers. So if anybody out there feels generous, please subscribe to the channel, because then I hit 100. And not that anything magical happens, except my positive. I feel more positive. My children laugh at me less. But it'd be good to get there. So let's see. We got some comments. Here we go. We got a comment here from Ginger G. How far back can you challenge historic decisions, please? That's a good question. What do you guys think?
I guess it depends so I think the kind of example we were given earlier about a previous intentional homeless decision that where the kind of there's been no accommodation in between. So that case we were talking about before, essentially, that I think, if I'm reading it right, it relates back to a decision that's 8 years old, and effectively what happened was they'd got a psychiatrist to assess this lady, and the psychiatrist was satisfied that yes, she did in fact have a mental health breakdown 8 years ago, and that was kind of one of the reasons why the housing officer wasn't having it, because he said that's too far ago. But effectively what we see in this case is, although it's technically not challenging that decision, or the decision will be challenged with the subsequent application. So that's there. I mean, that's an example there. In terms of kind of complaining and stuff, generally speaking, the LGSCO will say it needs to be within 12 months, as will most complaint procedures, complaint policies. But I've found that if you only just become aware of a historic failure, then the LGSCO can investigate, they can make a finding. So I'd imagine we're not looking. I mean, with statute limitations, I'm not even quite sure what that means, but I think that means in most areas of law, you've got 6 years to to bring a claim. So I'm just trying to think. The last LGSCO one I got was like, no, it's 4 years old. It relates to something that happened 4 years ago. There've been a whole sequence of events since then, so it wasn't like it was just a random historic thing. It was like that had then caused lots of other problems down the line, but there was compensation payment for that that 4-year-old error from the council.
My view is that you can actually go back as far as you like, or well, there's no time limit to a challenge. It's because what you would be doing if you obviously, if you have a historic decision, you've got 21, you've got your normal sort of section 202, 21 days, and then 21 days to appeal from the date of the decision. But if new information, like we were talking about earlier, comes to light, then you can invite them to reconsider, and then it's that refusal to reconsider that you're challenging, rather than the historic decision. So time would start running from there. So I reckon you'd be okay. I mean, and that by challenge I mean legal challenge. I mean complaining to the ombudsman. Yeah, you'd be a bit stuck if it was more than 12 months ago, wouldn't you? Um, so if that's sorry, Karis, did you want to add anything to that? Okay, so I'll come to this next one, which is from Anthony. Hello, Anthony. What if a person from Sussex was told by Bournemouth that they couldn't house the person from Sussex, as Bournemouth couldn't do a home visit in Sussex housing situation? Home visit to clarify the person in Sussex's housing situation. So basically, they're saying you're too far away, um, and so we can't process your homeless application because we'd have to come all the way to visit you, or you'd have to come all the way to us. So my view is that the answer to what if I would say is that would mean that the Bournemouth were acting unlawfully because the distance in. I mean, essentially, somebody can make a homeless application to any authority, and the fact that they happen to be located at that time a long way away isn't in the reason. There's no statutory provision for that, and really, they could make arrangements. It's quite easy. They'd say, "Well, we need to make inquiries. We can have a video meeting with you. We could have a telephone conversation. We could even pay for you to come to Bournemouth on the, pay your expenses, because presumably the person wants to come to Bournemouth in the long run because that's why they've applied. Um, so I think that's nonsense. It's up there with we'd like to help you, but your needs are too great for us to be able to meet them, which I have, believe it or not, heard a few times. So I hope that isn't. Do you guys agree with that answer? That
Yeah, I mean, so
unless I'm
when
missing
housing
something.
officers, when they want to do a home visit, it's usually because I mean, because maybe let's say the homeless application was based on the fact that it was unreasonable to continue to occupy the accommodation. So essentially, what the housing officers would normally do is go and visit them. And what they're saying here is that, well, we can't be able to go that far away. The other thing Bournemouth could do is they could actually contact the local authority. Where is it? In
Sussex.
Sussex, and request that they cooperate. Now, they're not going to do that because it's just too much work. But there's no, yeah, you can make an application when you're threatened with homelessness to anywhere, and the prevention duty doesn't like kind of relate to local connection. One of the things that councils can do is they can then like work between different councils to cooperate to actually conduct the inquiries. So I mean, as I say, it would be quite impractical because what's probably going to happen is the Sussex council would say, "Yep, it's definitely unreasonable. It's definitely homeless," because they want to essentially free up a home in Sussex and kind of get someone moved over to Bournemouth. So they probably won't do it, but it is open them to do that. So I think, yeah, I agree. Well, it's yeah, they need to figure out what it is they need to know, and then see if like video evidence or something like that can suffice. And if it doesn't, then tough. They need to accept whatever duty is likely to be owed to that person.
Yep, I think that's right. So that's that one. So I've got Tiff has put OMG. I'm not sure. Oh, sorry, I haven't. I'm not sure what point you put that. I hope you were commenting on
It was about the case you're looking at, the
Lord Denning.
Lord Denning. Yeah.
Oh, good. That. I think that's the appropriate response. Well, an appropriate response. So we got Tiff saying, I also wouldn't like to know that Ginger. So I wouldn't like to know that, Ginger. Sorry, maybe did I miss something that somebody had made a point?
But they were I think they were asking the same question about how far back can you go. I
Oh
think
right. Oh yes. Sorry. I would
I think
also.
so.
Yeah. So I hope that answers that one. Then we've got Cheeseface has joined in on the Lord Denning. Yeah, Lord Denning wasn't. I mean, the thing was that at the time, in the old days, Lord Denning was seen as a champion of justice, believe it or not, and he was seen as rooting for the little man against the system, or against the vested interest, which was nonsense. But he did do a couple of sort of eccentric cases where he gave that impression. But I'm pleased to see that nobody's. I mean, well, I'm glad that you haven't heard of him in the sense that it means that nobody's quoting him and saying anything about him now. And I think the legal establishment is embarrassed that he was ever promoted as far as he was. Then again, it's distressing that the appalling. I mean, the depths to which he sunk, are forgotten about. Um, But the yeah, I mean that's I'm glad I found that judgment again because I heard about it years ago, but I just couldn't remember. And because I don't do criminal law and stuff, it hadn't come up. But I'm glad I got
On
it.
a
So yeah, sorry.
on a slight tangent, I'm sorry, I know there's a couple of questions coming into the chat there, but just very quickly, because I know that the law has just changed to basically mean that family law judges can't be anonymous anymore. And I don't understand the story well enough to understand kind of how it's got there and stuff. Um, and the fact that the journalists can now report to some extent on family court proceedings. But I just wondered, like, and I wondered whether that was because essentially there was this kind of presumption that the judges in the Sarah Sharif case had basically been ridiculous, because that seemed to be the case that changed it, like, so that there was kind of, they remained anonymous whilst it was being reported on, and there seems to have been some really serious errors there. But I don't know if I maybe got the wrong end of the stick there. And the same kind of question around the
Yeah.
post office scandal, whether like any of the judges there were like basically, they're going to be open to criticism from for making bad decisions at some point. I don't know.
Yeah.
Yeah, probably maybe a question for another time, but I just
No,
thought of it.
it's an interesting question. What? Sorry, were you going to say something, Karis?
All right. I am keeping up with the family law court things because
Oh, right. So do
there's more
tell.
transparency rules, but it is quite interesting how it's going to go. And there are some judgments that are really criticized, but they talk about who they're talking about, and it's especially custody cases. They want them to get private and things like that. But it will be really interesting to come out of it, how they change, how they keep the balance of keeping the, because justice needs to be seen to be done is the fundamental rule of law. How does that work in protecting people's privacy, and especially in family cases, because you've got children that then will grow older and their adult life will be subject to these court cases and court hearings.
I
Sorry.
th- no, no,
Yeah.
thank you. I think it's the principle is that these courts are making incredibly important decisions about people's lives, but until now they've been subject to no scrutiny. It's not just about naming the judges, which is one thing, but about not being able to report on the cases and say what's going on. So that'll be interesting. I mean, I must sound like I really hate judges from what I've been saying earlier, which I don't. But one of the things I do feel worried about in naming judges and personalizing it is that where you've got sort of very emotive cases. I mean, I suppose the Birmingham Six was a pretty emotive case, but the if you've got things where people are I don't know, the Sarah case. That I mean, if judges are sort of targeted, and the media and vigilantes and people, I mean that's a worrying thing. But I guess it goes. I mean, maybe you could anonymize the judge in the sense you could identify them without saying who they are and what their full name is, because I don't necessarily see why it has to be somebody who you can sort of track down and possibly victimize. I don't know what you guys think about that. I mean, it is pretty dangerous. I mean, if you look at, you've ever seen those cases in Sicily where they were trying to crack down on the mafia, and I mean, the
Yeah.
judges had a life expectancy of not very long, get blown up on the way to court and stuff, which you don't
But I
want to
guess
see that happening.
the question would be then, so if there's a problem with judges making bad decisions, like, more than once, there needs to be, if you're not going to kind of have that sort of scrutiny from having it reported on and stuff, then what's your other mechanism to ensure that it's
Yes.
robust? Because yeah, again, if we're talking about quite a lot of bias and stuff over time and some poor decision making, and this whole, I've been reading the Robert Sapolsky book about the whole thing about, like, the further away you are from lunch, the worse your sentence is going to be. So, like, if you're seen last, literally, like, the statistical significance on the research that they did is alarming. Like, genuinely, like, if you're the last person to be heard that day, you're not getting parole, you're going back to prison, irrespective of what the grounds are or anything. Because at that point, the judge is just basically, just your head's too tired to actually make any decisions. So you just say, well, I just default to sending him away again, sending him back. But yeah,
my
anyway,
my gut
there's quite a
feeling
few
on that.
questions coming up now.
All
Just
right.
noticed. So
Great.
yeah,
I'll change that then. I'll just say my gut feeling is that they could name the case and denounce what was said in it without naming the judge, and then the legal, the judicial authorities, if we could trust them, could deal with the judge. Because you've had all those cases of rape victims being bullied and judges making ridiculous comments about people convicted of rape as if it's not serious, it would make sense to highlight the case and then sack the judge discreetly. But I guess nobody would know it had happened. So unless they announce that a judge who dealt with this case, who will remain anonymous. But anyway, we'll move on. So Tiff, is this the one you mentioned, Mike?
No, I think the next question I can see is DC, unless I missed one.
I'll come
So
on. I'll
if
just
someone's
mention
medical needs, yeah.
Okay, I won't stray too far, but Tiff, yeah, I mean, the problem is after reading, it's a bit like, I don't know if you watched. There was a series on the BBC about the OJ trial, and it was called. It was about 8 episodes about the LAPD, and I don't know if you. After I watched it, I mean, I don't like to wade into another controversy trivially, but if I'd been on the jury in the OJ trial, knowing what I knew about the LAPD, Los Angeles Police Department, I would have found the guy innocent, even though my gut feeling says he was guilty as hell. But you just couldn't believe a word those people said. And it was almost necessary for the interest of justice to find against anything they said, which I should add, when I was starting off in law in the 80s, in criminal cases, I used to go and sit behind counsel. It was a well-known fact in London that the public, the juries, would prefer not. They wouldn't believe the police. So police evidence was not believed over criminal evidence because the police were so discredited. But that's another story. So yeah, the Lucy Letby case is an interesting one as well, isn't it? Because it's so emotive, and it's such a tragic situation. But I still think there's an element of burn the witch here, which
Do you think the subject,
sorry, go on.
Do you think because the subject was babies, it was more emotionally charged?
Yeah.
There was a bit of bias, yeah.
Well, I think it sort of prevents people from thinking clearly, doesn't it? Because it used to be in the if back in the 70s, if you ever questioned the validity of the convictions, because most people recognise that these people, well, a lot of people recognise that these people hadn't had a fair trial. And the interesting thing is, even the prison authorities, within a very short time of these guys being in prison, the prison authorities were giving them a regime which would have been for a normal prisoner. No IRA prisoner was allowed, for instance, to have visitors in the main visiting place. But all these people, within a very short time, were given normal visiting rights, which shows that the prison authorities didn't believe they were guilty either. But anyway, if you said anything, it would be, what do you support the IRA? Is that what you're saying? And so you never got past that. And so with this one, I think you're into the thing of, oh, you think it's all right to kill babies, do you? Which obviously you don't. But I think, and it shows also the difficulty of dealing with expert evidence. But that's another story. We'll maybe talk about that another day. All these cases show that experts and lawyers don't mix very well. Because nobody understands what they're talking about. So here we go. So that's probably, there we got Cheeseface saying, I agree with you. Many men nowadays even ignore ladies being attacked in the streets and walk by. It really annoys me. It never used to be like that back in the olden days, did it? Well, I think you'd be surprised, but maybe you're being sarcastic there, Cheeseface. I don't know. Or Tiff, sorry. I think that ladies were getting attacked in the streets and quite a lot. So if someone's is it this one, Mike? This is the one. Yeah, sorry, we're back to housing. Welcome back to housing law. I know it's quite interesting to take a little detour away from housing law because it is called William Fleck's Law Channel rather than Housing Law Channel, but it is what I know about the housing law rather than the other stuff. So, but it's quite interesting to get a conversation going. So here we go. DC says, if someone's medical needs significantly changed since making a homelessness application and a full duty accepted, should the council do an updated assessment on medical needs or an updated PHP? Okay, Mike, I can tell you were interested in that one. So do you want to dive in?
So it's a really good question. I think I'd need to check out. I think the PHP essentially only exists until the main duty is accepted, I think the duty to keep it under review is only until the main duty accepted. But I'm assuming here that if the main duty has already been accepted, then the relevance of the medical need is the suitability of accommodation that's then offered. So I think that although technically the PHP doesn't need to be kept under review at that stage, if you were to tell the council, now I don't know, maybe it is, now I can't get up a flight of stairs or something, then they would be under duty to ensure that when they then show, kind of selected accommodation for you to discharge duty into, they would need to be able to show that they took that into account. So I think in one sense you get the same effect. The end result is the council still have to take it into account. I just don't think it will be done through the PHP mechanism, but I might be wrong about that. As I say, I'm not quite sure when the duty to yeah, in fact, I'm pretty sure the PHP only needs to be kept under review until the relief duty ends, which it would have by this point. But yeah, so I think, but what you
Well,
want
we'll
to
have to
do then
come
is
back to that.
basically email the council and just say, these are my new medical conditions. Just I therefore can't accept whatever, first floor accommodation or something like that, or accommodation with stairs, or whatever it might be.
So you think that do you think the duty to assess stops then as well? I mean, at the point when they've accepted a duty.
I would need to go and read it around,
Me
but
too.
that's my impression. Yeah, I think I'm just trying to think of the homelessness code guidance, and it's very sort of centered on the relief duty, and then sort of the main duty is accepted if you get through it all, and it sort of just drops off a cliff really. I'm gonna have a little dig around on the homelessness code of guidance whilst we're talking now and see if I can find something.
Okay. Because I was about to start that, then I thought, oh, it's 8:33, so we're getting towards the end of the session. But I was sorry, have I got the camera up with? It shouldn't have Shannon blank there. But I think I have, haven't I? It says Shannon Johnson. There's nobody there. But can you see that on your screens, or am I? Yeah. Sorry about that. So the other thing I was thinking was that regardless of whether it's an ongoing duty under 189A to assess and do a new PHP, presumably if the significant change is relevant to that person's circumstances, then the council would have to consider it. For instance, if they're in accommodation which is unsuitable for them, then that would give rise to an entitlement to make a fresh homelessness application on the basis that their accommodation is unreasonable to continue to occupy. So, and also, I suppose if the council they've accepted a duty, so they could be saying, right, we're now going to make you a 193 offer of some accommodation which is now unsuitable because of the change. Then obviously you'd be able to say, well, it isn't suitable for me, and they'd have to carry out a reassessment, if only as part of considering what you were saying. So materially, I mean, I my gut feeling is that the duty carries on, but I don't want to be wrong about that. So I'll wait till Mike looks up. But I'm
So
saying it doesn't really
yeah,
matter if it is a significant change that the council needs to consider now. So what did you find, Mike?
So 11.32 of the Code of Guidance, assessments and personalised plans must be kept under review throughout the prevention and relief stages, and any amendments notified to the applicant. Blah 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 blah. Doesn't it? I just don't. I don't think it really. I think when they came up with this ridiculous bit of the law, I don't think they were thinking in terms of the kind of longer term.
Okay.
So I can't see anything that's saying that the PHP basically runs past the end of the relief duty.
I'm going to
I'll
check
keep
that
reading.
out. Yeah, I'm going to come back on that next time if that's all right, because it would be good to give a clear answer. It would be very disappointing if it doesn't, because the whole assessment process is relevant to things beyond the acceptance of a duty. But like I say, if the changes make a significant change are significant, then it would give rise to a fresh application anyway and take you back to the realm of a new duty having to be considered and an assessment carried out before that. So I've got another. I hope that helps. We'll come back. Stay tuned for that one, DC. And then we've got Adams asked, what are the grounds that differentiate accepting you as a homeless, intentionally homeless, in the context of when the HPO is looking at your review?
Homeless prevention officer.
Yeah. So we've got lots of new questions. So I'm going to quickly try and answer that. So what are the grounds that differentiate accepting you as homeless? Well, sorry, Adam, if I'm missing something, but the two questions here would be whether you are homeless and whether you are intentionally homeless. And those are different criteria that the council have to consider. The one is whether you've got accommodation that's reasonable for you to continue to occupy, which would be homeless. If you meet that, broadly speaking, you're not homeless. And if you're then whether you lost accommodation as a result of deliberate act or omission, which would have been available to you and reasonable to continue to occupy, you're intentionally homeless. Now that the context of who is looking at it and when doesn't really matter, I don't think. I'm sorry if I'm. Do you think I'm missing something, guys?
I seem to have now lost the part of the question because I saw it and now I can't see it. So I'm not going to be able to help you out right now. So there's at least two parts to it.
My friend application is going through review whether they are homeless or not. They are under review and hasn't been accepted or rejected in terms of the main duty. What are the grounds of? I think there might be a bit more of being rejected.
I kind of. So yeah, I guess the headline is that each of the 5 tests are kind of carried out separately, although they do interact. So, for example, as I think Will just probably said, you're homeless if it's unreasonable to continue to occupy your home, and if that, essentially, if that's true, then it's impossible to be found intentionally homeless from it. If that's the reason for you becoming homeless, if your accommodation was reasonable to continue to occupy, then something changed so it then wasn't, and then after that you lost your accommodation. Let's say it happened like that, then you wouldn't be intentionally homeless. So I'm not quite. Yeah, I think we might need a bit more information to make sense of that.
Yeah,
certainly I do anyway. I'm not quite sure what else what would happen.
I'll just go back. So we've had that one. So I'm just looking. So DC's made a comment. Council seems not to want to do either. The child would need a property suitable for. Oh, I think I may have missed.
So this is the question about. So we're talking about whether the PHP continues, but after the main duty. So I think in that situation, you basically just want to write a very an email with capital letters saying this is a change of facts around suitability. You need to consider this new information, and probably because the number of time councils continually offer unsuitable accommodation, it's probably worth just really kind of hammering that home and just kind of attaching medical evidence and just kind of asking the officer, can you confirm you've read this information, just so you've got kind of that sort of proof of that it's been considered. I mean, I think ultimately, if they then offered unsuitable accommodation, it would be quite easy to challenge, but you obviously don't want to get into that argument if you can avoid it.
Yeah. So again, if the child is not in accommodation which is suitable for a certified visually impaired person, then you're entitled to say we're homeless because of that. If I'm not, that would be the argument I would make. So Cheeseface has said the fundamental rule of law is that it needs to be seen to be done. That explains a lot. Well, yeah, I mean, I've never quite understood that, whether you're just going through a charade of putting a wig on someone and making it talking in a oldie worldy voice means that justice is being done. But
there's a great line in that. You've seen Gangs in New York. There's Jim Broadbent's character, and he says that he's a proper corrupt politician. He's saying, the appearance of the law must be upheld, especially when it's been broken. It's like, yeah, that's kind of how it is often, isn't it? Just what it's all about.
Yeah, sorry, I just got to give somebody a key. So I'll just get the last of these. Then we've got. So Anthony said, "Thank you. It's a form of gatekeeping from. I think it's a form of gatekeeping from Bournemouth. I hear they got a terrible rep. Is that going to say reputation? No.
Yeah.
But I think it was.
Bournemouth historically has been really. I mean, I've not had recent contact with them, but going back a long way, they have like this kind of reconnection policy where people just turn up there and they just give them a bus ticket anywhere else. So, and I doubt much has changed. I mean, it's a different council now. I think it's Bournemouth, Christchurch, and Poole. But I mean, basically, it's such a desirable place to live. They've always had a problem with people coming down there, but that doesn't mean to say they don't have to follow the law. So yeah, I have heard similar things to Anthony.
So we got Tiff pointing out that on the Daily Mail newspaper years ago, Dr. George Hibbert, psychologist of Tadpole Cottage, no less, was paid extortionate amounts to write falsified reports for social services to keep people's kids. Yeah, I mean, this is the sort of thing. I mean, unfortunately, one of the other characteristics of the Birmingham 6 case was that they relied on the expert evidence of a scientist who was 99% certain that all of the 6 men had handled nitroglycerine, i.e. bomb-making equipment. But it turned out that the test he used would have found you positive if you'd been using, basically, if you hadn't touched anything and if you'd been playing cards and stuff like that. And eventually his evidence was completely discredited. But the corruption was just terrible. I mean, he was best mates with the chief of the Birmingham police force that was involved. I mean, it just, the levels of corruption in that case are just breathtaking. And so with this type of thing, I think when you're dealing with, experts, you really have to question and look at the detail. But the problem is nobody has time to do that. So when this guy, Hibbert, was doing it, the problem is how do you say, well, he's obviously, it's falsified. You have to, I mean, in the Birmingham 6 case, they had to get experts to look at all the police notebooks and look at the writing underneath the page, and then look at the styles of handwriting, and they found that they'd been completely fabricated, but it took many years. So, as Tiff's corrected us, I wasn't being sarcastic or rude. I was simply only meaning that things are very different nowadays. Oh no, I didn't. You didn't offend anyone, Tiff. I just didn't think that the good old days are quite as good as sometimes they seem. But sorry, maybe I'm making it worse. But no, your comment was taken in good faith. So yes, I hope you're not getting blamed for what I wrote, lol. No, that's fine. Adam's asking, what test does a homeless prevention officer use to accept someone's main duty? Also, what do these tests consist of? Guys, do you want to jump in?
Yeah, I can. So there's, I mean, in terms of the main duty, there's 5 tests. So are you homeless? Are you eligible? Which is like having recourse to public funds. Are you in priority needs? Do you have local connection? Although there's various ways out of that, so that's not actually so important. And are you intentionally homeless? And they're all taken separately. So, just because. So I've heard kind of. So for example, let's say you've got a pregnant woman who is in priority need, but she's also intentionally homeless. The council would not have a long-term duty to house her. They have a short-term. But then you kind of hear professionals saying, yeah, but she's pregnant, she's in priority need. It's like, yeah, they know they're saying that, but it's a different test for unintentional homelessness. That's the thing which the council's using to kind of say they don't have a duty to house them. So they kind of standalone tests. Although as I say, there will be, so as an example, like if you're homeless because of domestic abuse, that makes you homeless, but it also happens to also mean you're immediately in priority need. So some of the ways it works in different situations will follow through. So same thing would be like, then if you're homeless because of domestic abuse, you're also in priority need. You won't be intentionally homeless, and local connection doesn't really kick in. So you can kind of see how some things do kind of relate to each other. But generally they're kind of standalone tests. So the council might accept that you are homeless and you are in priority need, but you're intentionally homeless, so there's going to be a different duty owed to you. Yeah, if that makes sense.
It does, yeah. I would say that in my experience, the tests were always used. The analogy I always think of is trying to run a hurdle race, and the council staff will try and get you on one of the hurdles, and they'll get them higher and higher, and they'll think, oh, that we might. You said it might, didn't you? That quote of yours, get them on the easiest one, which they will try and for them it's easy because they can just say, oh well, you're not homeless because the people you're sofa surfing with haven't got a court order against you or something, and that's obviously a load of nonsense. But the chances of somebody challenging it maybe are such that they're only a percentage of the people that get that sort of decision challenge it. So they used to just try and catch you on one of them, which if you were lucky you could challenge it. So I think that is it for tonight. Unless I'll just check if we've got any more. I think this is the last comment for tonight. I know we've got. Hang on, we've got another comment. Oh, Tiff, just in case you're worried that you've been cancelled. I'll put you on again, so to welcome back. And it says, fortunately, one mother ran out of George Herbert Assessment Centre and blew the whistle. Unfortunately, the GMC appeared to also possibly corrupt, as also discovered during the pandemic, I think is the word. Yeah. Although the pandemic, I'm going to avoid straying into that territory of conspiracy. I mean, not that, and there's a lot of stuff out of that one. But I would say my view on corruption, for what it's worth, is that corruption is inherent, and it is all pervasive. And if you think you see corruption, you may very well be right. I mean, that's not to say every conspiracy theorist should believe it, but often when these things come out, the truth is even worse than you possibly imagined, as in the post office case and the I'm going to say it again, the Birmingham 6 case. So I think this is really winding up for this evening. So Adam, I think I'm going to just give a quick on. Legally speaking, in any case, does the HPO have time constraints to make a decision? I think we've covered that a few times. It's a reasonable time, isn't it? I mean, if you've got a complicated case, they can take longer. They're supposed to. Mike, do you know the actual guidance figure?
So once the relief duty started, which is in itself, you need to chase them sometimes. The relief duty should really happen shortly after making the application. Then the council's got 56 days. In the case where the main duty is owed, it's got 56 days to do their inquiries. They should issue the decision on day 57, and then in exceptionally complicated cases, there's an additional 3 weeks. So if you're like on day 57 or afterwards, it's in your interest to chase them, basically because you're going to be, you at that point you want them to accept the main duty. So you want the relief duty to end if you're in priority need, not intensive homes, and so
on. Great. Well, thank you. And I think that is it. And I can announce. I'm very pleased to say that thanks to whoever it is that subscribed, but I now have 101 followers. So I'm that bit closer to having that YouTube placard behind the silver thing that people have to show they've got. How many do you have to get? Is it 10,000 or something to get?
I think it's more than that. I think it's more
no,
like 100 or something. I don't know.
Well, you never know. I mean, the black belt lawyer and the art of law or whatever, they seem to have managed to go viral, or whatever the term is. So thank you, everybody, and thank you, DC, for your comment. And I'm afraid I won't be around on Thursday this week for Mike's show, but I'm hopefully see as many of you again as possible on next Monday. One thing I noticed here that somebody, sorry, was it? Yeah, Adam, you said that you were going to pass on these videos to those in need, which thank you. I hope it helps. But if there's anything anybody can think of that you'd like to see videos dedicated to, or I mean, it's always interesting to just have a general chat and we can answer questions. But if there's subject matter which you'd like explaining more or look at in more detail, then please let me know, because I keep meaning to make videos like Mike does, but I haven't got us off the ground with that yet. But please put comments on the end of here and let me know. And also, just the last bit I'd say is I don't know if the link has come through. Can you see the actual YouTube video, guys? Because I'm not looking at that, because I put a link to the Notion page. I tried to when I was setting this up. But if people are in need of legal assistance, then send us a message. I mean, don't do it on here, and don't give your details on the comments stuff. But there you should be able to find a link, which I'll publicize better next time, to how you can give us your details, and we can look into taking on your case. And you don't have to be in London. Thanks to modern technology, we can do this remotely from anywhere in the UK. Or England and Wales anyway, whereas the law's the same. So thank you very much, everybody, and I'll say good night for now. Oh, hang on, we got what we got. Tiff says, "What about a free chat about anything one day? Legal question." Oh, haven't we just been having that for the last hour? But Yeah, I mean, you mean a personal one-to-one free chat? Um, yes, I mean that's true, but obviously I've got to earn a living, so it's a bit difficult to meet everybody. But if people have questions, oh look, golly, I'm getting lots of responses. Sorry, I'll just put these up. So yeah, free chats. I mean, we could look into that, but I think if you just sign up as a client, if you've got a problem, I mean, I'm assuming most people who have this sort of problem may be entitled to legal aid, but if not, there are ways you can get a fixed fee interview if you have more than the legal aid limit. But I'll maybe I'll put a post about that, how to get legal advice. So quick ones here. We've got a day in their shoes. Follow a homeless person for 24 hours, documenting their struggles, interactions, and moments of hope to create empathy and understanding. That's a good idea. I think there was many years ago, I think 1966, Ken Loach did this when he made the film Kathy Come Home, which led to the formation of Shelter, I think, and had a big cultural effect, which I think is on YouTube if you want to find it. But that was dramatized. But I mean, the difficulty of following a homeless person, I suppose you're going to get, as soon as you get into the homeless persons unit, you're going to have security stopping the filming. I suspect they're not going to welcome you in there. But yeah, that's it would be good to get more lived experience from people who've had this, although presumably a lot of the questions are based on that. And we've got one more, and this is, yeah, we've got hidden homelessness, those facing insecurity but not yet on the streets. Definitely the homeless at home would be useful to talk about. And rebuilding lives, showcase success stories of formerly homeless individuals who overcome addiction, found housing, and rebuilt lives. Include their journey and current efforts to help others, I think. Yeah, okay. Well, thank you very much for those thoughts. I think from our point of view, I think the hidden homelessness would be an interesting one to cover. I mean, it's difficult for us to comment on a lot of the other stuff because I don't know where the people to approach are, but we'll keep thinking about it. So thank you very much, everyone. I'll see you next week, and have a good week till then. Bye bye. So